right, so we're recording. Welcome to the Wednesday webinars. Today's webinar is on divorce and farming. We have Sarah Everhart that will be speaking. Here's a list of some upcoming ones that we have. To register or find out more information about upcoming webinars or archive webinars, you can go to extension.umd.edu/women in ag. We would like to thank everyone for a successful 2018 Mid-Atlantic Women in Ag Conference. And we do still have two classes for Annie's Project, one on the Midshore and one in Central Maryland that will be starting in the next couple weeks. So if you have any interest in those, again, go into that website. You can get some more information on those. So we still have two Annie's Project classes open. Would like to thank our sponsors for the Mid-Atlantic Women in Agriculture program, and then also recognize the collaborators on this. So with that, I'm going to turn over the webinar to Sarah, and I'm going to pass you the presenter ball. And thank you for everyone being on here today.
Thanks, Shannon. So thank you all for tuning in on this romantic topic that we're going to be talking about today on Valentine's Day. I did schedule this on purpose with Shannon, tongue-in-cheek, to talk about love, and how to protect the family farm when love goes wrong on Valentine's Day today. So I work for the Agricultural Law Education Initiative. It is a partnership of the Francis King Carey School of Law at the University of Maryland, Baltimore, the College of Ag and Natural Resources at the University of Maryland, and the School of Agriculture and Natural Sciences at the University of Maryland Eastern Shore. Part of our funding comes from the University of Maryland Empower program, and that is a program that brings together the different parts of the University of Maryland to try to create collaborations. We have a website. If you've never checked out our website, it is umaglaw.org. I encourage you to check it out. We educate farmers throughout the state on a variety of different agricultural legal topics. We also research and write easy-to-read publications on these topics. We have a quarterly update that you can sign up for so you can know what new resources we have coming out and what events we have coming up. And you can also find a link to our blog. It is the Maryland Risk Management Education blog. The legal specialists write for it. It's also sponsored by the Maryland Crop Insurance Program and the University of Maryland Department of Ag and Resource Economics. We update it a couple times a week, and it's a great place to find answers to common ag law questions and answers. All right, so I'm going to dive right in and talk about farming and divorce. Please feel free to interrupt me as I go today. Type in the chat box and ask me any questions. I will try to answer them to the best of my ability. If I can't answer them as we go today, I will give you my contact information on the last slide, and you're welcome to contact me, and I will help you as much as I can following today's webinar. I'm just here to give everyone educational materials and information today. I'm not giving you individual legal advice. If you need individual legal advice regarding this topic, please consult your individual attorney. So what makes farming divorces different from other divorces? Well, it's quite a few things. As we all know, a farm is more than just a typical business. It's oftentimes passed from generation to generation, and many people consider it a way of life. Divorce directly challenges the ability of both spouses to continue that way of life and to preserve the farm for the next generation. Another thing that makes farm divorces challenging is that farms are often not very liquid. So the lack of liquidity, and by that I mean there's often not a lot of cash sitting around. There's more often valuable land, valuable equipment, potentially valuable livestock, and that sort of thing. And this lack of liquidity can make the equalization of assets difficult. So I'll talk to you today about the process of divorce and what the role of the court is. But as you'll be hearing more about, the court in a divorce is put in a position where they have to equalize the assets. That can be very difficult if there's not cash around, because that means we're going to end up in a situation where we're probably potentially going to have to sell equipment, sell land, that type of thing. Unfortunately, a lot of farmers often don't have typical retirement savings accounts either. It's not like, you know, your 401k with a large amount of assets in it or a pension. And we hear from some folks that, you know, the farm is the retirement plan. That can make things difficult because in a divorce, you also have to equalize those retirement assets. And if they're not in a typical account, that can be a challenge. So attorneys and courts in this situation have to come up with some creative solution. And we'll talk about ways to try to protect yourself from these situations, but you know, sometimes rental income can be used, insurance policies, structured payments, and some folks would even prefer alimony rather than having to sell the farm. Oh, sorry, skipped one too quick there. Okay, so farming specifically in Maryland. Maryland is an equitable distribution state. What that means is that we're not a community property state like some states, most states, some states in the western part of the country are, but here on the East Coast, and in Maryland, we're an equitable distribution state. That means that in a divorce, a court is going to classify all property as either marital or non-marital. Then it's going to value the property and divide the property between the spouses in an equitable or fair way. Keep in mind I said equitable, not equal. It can be nearly impossible for a court in this situation to do things exactly equal, but they try to be as equitable as possible. Thought it was worth mentioning the difference between an absolute and a limited divorce in Maryland. It's oftentimes a confusing topic for folks. An absolute divorce is what you think of as your final order of divorce. So after you've, you know, been separated for a period, potentially gone through court action, or if you've, you know, settled out of court, if everything's settled, if you've asked the court for that final order after the judge signs that order, that is your absolute divorce. A limited divorce is you can get a limited divorce in Maryland. A lot of folks don't go through the effort of getting a limited divorce because really what it is more akin to a legal separation. So sometimes folks go in and ask for a limited divorce, and the reason they would do that is if they needed some kind of temporary support prior to the issuance of the absolute. So if you needed child support or if you needed some kind of marital support before you got that order of absolute divorce, you would seek a limited divorce. Okay, so like I said, the court decides which assets are marital, values the marital property, then divides the assets. They can do this by transferring ownership of property, granting a monetary award, or both as an adjustment of the equities of the parties, and that's whether or not alimony is awarded in the case. Alimony is handled separately from the valuation and division of marital property. It's a part of the overall consideration, but it's sort of thought of and dealt with separately. And clearly, if there are minor children in the family during a divorce, there are other steps in the process. I'm not going to be going through those today. I'm not going to be talking about child support or child custody, but just wanted to put that out there. So when a court considers granting a monetary award, and by that I mean, you know, the court is going to decide which assets are marital, value them, and then say spouse A owes spouse B X number of dollars in order to equalize the assets. There's a number of considerations that the court considers, and so I'm just going to go through these fairly quickly so that you understand. These are directly from the family law article of the Maryland Code. So they are the contributions, monetary and non-monetary, of each party to the well-being of the family. So even if a person has been a stay-at-home spouse, that non-monetary contribution is considered. The value of all property interests of each party, the economic circumstances of each party at the time the award's made, the circumstances that contributed to the estrangements of the party, so that is whether or not, you know, one party potentially strayed from the marriage, or one party was cruel, and that's what caused the breakup of the marriage. That is a part of the consideration. The duration of the marriage, the age of the parties, the physical and mental condition, How and when specific marital property interests were acquired, including the effort expended by each party in acquiring those interests, contributions by either party of non-marital property to the acquisition of real property, held by the parties as tenants by the entireties. Tenants by the entireties is the way that folks own property in Maryland when they're married. So if you, during the course of your marriage, if you acquired real property and you held it as husband and wife, and one of the parties used non-marital assets to acquire that, that's taken into consideration. And I'll go into that in a little bit more detail here in a second. Whether there was an award of alimony, and then finally the court has the discretion to consider any other factor that they consider necessary and appropriate to be able to arrive at a fair and equitable monetary award. So this really gives the court a lot of discretion to consider the whole factual circumstances of the parties. All right, and so when the court is taking a look at assets, keep in mind they're also going to be considering debt. So they're going to be considering marital debt, which is directly traceable to acquiring marital property, and then non-marital debt that's not directly traceable to marital property, such as premarital student loan debt. Just to use an example from my own life, premarital student loan debt would not be considered in terms of my marital debts. So if one spouse attempts to get rid of marital assets or lower the value of marital assets through debt or otherwise, it could be through a sale or gifting, in anticipation of a divorce, that is not viewed favorably by the courts. Folks tend to try to get away with this quite often. The courts are very familiar with it, and it is not a good idea, and it just will not result in anything positive for the person if they're found to be purposefully trying to rid themselves of marital assets when they know a divorce is coming. All right, so I've been talking about marital property versus non-marital property. What are these two categories? Marital property is property, and when I say property, I mean land, equipment, basically everything. So I'm not just talking about real property, which is land. I'm talking about all your assets, however they're titled, acquired by one or both of you during marriage, unless excluded by a valid agreement. So that's a very broad definition. So that could be retirement savings, that could be land, that could be livestock, basically anything with any kind of value that either one or both of you acquire during your marriage. Non-marital property is property that's either been acquired before the marriage, acquired before or during the marriage by inheritance or gift, excluded by valid agreement, and that's typically a prenuptial agreement, or directly traceable to any of these sources. So basically, non-marital property is defined very narrowly. So if you get property by inheritance or gift, clearly non-marital. If it is validly excluded by a prenuptial agreement, it's considered non-marital. Or if it's acquired before marriage, it's non-marital. But other than that, typically things are interpreted to be marital property. This is important because farmland is often traceable to non-marital sources when we're talking about family farms. So common for folks to inherit farmland or for a farm to be passed down in a family and for a person to get farmland by way of a gift. And those are two of the main ways that, as we just heard, that property can be considered non-marital. Non-marital property remains non-marital property if it can be traced to a non-marital source. So let's dive into that a little bit more. So non-marital property, it's often the case where we get something by inheritance or gift, and if you're married, things can quickly become commingled with marital assets. So in the case of cash, if you inherited cash or were gifted an amount of cash, if you put it into your joint bank account that you share with your spouse, and then you continue to use that bank account for household expenses, then you've commingled those two assets. The non-marital property and the marital property have been put together into one pot. It can also be transmuted or changed from non-marital to partially or entirely marital. So let's use an example here. So let's say that Mary owned 50 acres of farmland before she was married. That's non-marital property, right? However, after marriage, Mary and her husband use marital funds to improve the farm. They buy livestock, they, put up buildings, they make the farm more valuable over the course of the marriage, which would be a typical thing for folks to do. The spouses have then created a marital interest in that farm. So that property's gone from non-marital to partially or potentially entirely marital property. This is a case from a Maryland case back from 1991 that I thought was a good example of another way that non-marital property can become marital. So this is a non-farming case, but in this case, American versus American, the husband had non-marital real estate holdings. He got married. He actively managed the properties during marriage, so he subdivided them. He developed these pieces of real estate. The holdings appreciated in value during this time, during the marriage. To support that action, to support the husband, the wife worked separately, and her income supported the family and allowed the husband to manage the real estate holdings full-time. This is analogous to, I think, a situation that many folks are in where one spouse works off the farm. The spouse that works off the farm, that income is used to support the farming operation, whether that's through health insurance benefits or directly through the salary of the off-farm spouse. The court found in this situation that the husband's efforts during the marriage and the wife's contribution of her salary in support of the husband's efforts transformed the character of that previously non-marital property into partly marital property. So, takeaway from this case is don't be under the misunderstanding that just because you are working on a farm that you inherited or got prior to marriage, that it retains that value. That might not necessarily be true. It's going to be, the court is going to take into consideration all the factual circumstances. And if there's one spouse that even if they don't really have anything to do with the farm, if they're contributing to that and allowing the other spouse to be a full-time farmer, there could be a potential marital interest there. Okay, so what do? Ways to protect the farm. I'm going to give you a handful of ways that you can protect the farm in divorce. To prevent non-marital property from becoming marital property, the best thing to do is to just keep it separate from marital property. I know that's difficult to do, and probably, depending on the situation, could be darn near impossible. But if it's something like cash or if it's something like an investment account, something that you could keep separate, consider doing that and understand the ramifications if you don't. A title in and of itself is not determinative of whether something is marital or non-marital. So remember before, a couple slides ago, I told you marital property, regardless of title, is property that's acquired during the marriage. So if spouse A and spouse B are married and spouse A decides to go buy a beach house and he buys it in his name only, that doesn't matter. That's still marital property. It doesn't matter how something is titled. However, if the spouse inherits property and turns right around, within a short period of time or within really any period of time, and decides to add the other spouse onto that title, that may be used as evidence of the fact that the spouse didn't intend to keep that property marital. So if it is your intention to not change the nature of property from non-marital to marital, I would recommend that you don't change the title. If it's just in one name, don't add the other person unless it's your intention to make it marital property. One of the best ways to protect the farm from divorce is to consider a prenuptial agreement. I know this is not a very romantic subject to talk about, especially not on Valentine's Day today, but a prenuptial agreement It's a simple document prepared by a qualified attorney, and it just simply states which assets in a divorce are going to be divided and which are going to remain non-marital or not subject to division. So prenuptial agreements are a good way to exclude the increase in value of non-marital property obtained by marital effort. So the situation we were just talking about with the off-farm spouse and the fact that that salary was used to support the farming spouse and then used to improve the farm, which was non-marital. In that situation, the real estate holdings in that particular case, if that had been described and if it had been very clear in a prenuptial agreement that that was not the intention of the parties, that the intention of the parties in the event of a divorce was that that farm would remain non-marital, those folks would have been in a much better position. Things would have been much more clear. I encourage both women and men to consider prenuptial agreements. I think there's still some gender stereotypes in this arena, and I think that's unfortunate. Doesn't matter what gender you are, and it really doesn't matter how much property you have. If you have ownership of something, even if it's modest, I would encourage folks to consider this. It should not be a very expensive undertaking for any attorney to do. These should be fairly simple. For a prenuptial agreement to be valid, well, first of all, you should definitely have it drafted by an attorney. And second of all, it needs to be substantively and procedurally not unconscionable. And that's a double negative, so let me explain here what I mean. It needs to be fair. It needs to be fair in its content, and it needs to be fair in the way that it's presented to the other spouse in order for it to be upheld. So you can't have, it's not advisable to have a prenuptial agreement that is completely unfair to one spouse. So to leave that person with, absolutely nothing, to say in the event of a divorce, I get everything, you get nothing, that is the kind of prenup that would be found to be substantively unconscionable and would be subject to challenge. And that's the last thing that someone who would be relying on that prenup would want to happen. And then procedurally unconscionable, that's a situation where you give it to the bride the night before the wedding and you say you need to sign it or else we're not getting married tomorrow. To protect yourself in that regard, if you want to present your beloved with a prenuptial agreement prior to marriage, do it a couple weeks before, at least a couple weeks before the wedding. Allow that person the opportunity to have their own lawyer review it and potentially negotiate it. Prenuptial agreements, you should think of them as any other legal document. Have your own lawyer look at it. Clearly the lawyer that drafted it was doing it with his or her own client in mind, not the other party. And if you want to be able to say that the party you've asked to sign it at least had the opportunity to have their own lawyer review it. They might not take that opportunity. They may not hire an attorney to do that. But if you've given it to them with enough time, then they had the opportunity to do so. And finally, a prenup has to contain a full listing of assets. So it needs to be specific and list the assets that it wants to include, and that's someone who neglects to put valuable assets on a prenup. That's another way that a prenup can be challenged. They're legal documents, they're not foolproof, but they can be a good way to protect premarital property. Okay, what other ways can you protect the farm? Think about divorce during estate and succession planning. If the intention is to keep the farm in the family, limit bequests to blood relatives and exclude spouses. So if you want to leave the farm to your daughter Nancy, leave the farm to your daughter Nancy. Don't leave the farm to your daughter Nancy and her husband Jim. If you leave the farm to your daughter Nancy, she's going to get that farm by inheritance. And remember, inheritance is one of the ways that, that she can have that as a non-marital asset. If you give it to Nancy and Jim, they have both inherited the property. He has a property interest in that property as well. And if it's your intention to keep it in your bloodline family, then just make sure you're specific about that gift. Another important thing to think about is whether or not you want to use a trust rather than giving a straight gift or giving something through a will or as a bequest. So trusts can be really valuable in this regard. When assets are put into a trust, they're owned by the trust. They're managed by a trustee, and then the beneficiaries of the trust can get benefits or income from the trust, but they personally don't own the assets. The trust owns the assets. So trusts can be used to keep farms and families, prevent commingling of marital and non-marital assets. Again, trusts shouldn't be an overly complicated or expensive thing for a lawyer to produce, and I would encourage you to consider them for these reasons. Finally, this is a tip that I give folks. I practiced law for 9 years. I did have domestic cases during those 9 years, and based on my experience representing folks in divorce, the person who handled the paperwork during the marriage typically did better in the divorce. So don't rely on your spouse to handle all your paperwork. I know that this happens a lot in couples, that, you know, one person is maybe better at paperwork or just got stuck with doing all the paperwork, and the other one kind of turns a blind eye and trusts that the paperwork is being done. And by paperwork, I mean, you know, bank accounts, investments, all of your finances. Don't rely on your spouse to handle all of that paperwork. Keep track of your documents and take turns, even if it's only 1 month out of the year. Take a turn handling the paperwork and the finances. If you find yourself in a divorce, it's going to be very valuable that you have an understanding and an appreciation of your marital finances. And I think you're going to be at a disadvantage in a divorce if you are ignorant to that side of things. And I know this is common in the farming context. A lot of times there's one spouse that handles all that work. So, to review, ways to protect the farm. Another extremely important way to protect the farm is to agree on the division of assets. You don't have to go through a lengthy court battle in a divorce. Spouses may voluntarily agree on the division of marital property rather than asking the court to make the decision. I don't think any judge would relish having to order a farm to be sold, or, you know, I don't think any judge really enjoys going through a messy divorce case, and they would much prefer, and they try to encourage at every juncture, folks to reach an agreement between themselves. Those two spouses involved know their property better than anybody else is ever going to know it, and they understand the operation if we're talking about a farm, so they'd be best suited to agree on that division. Spouses can come to that agreement using attorneys. They can come to that sort of an agreement using a mediator, and then they typically record or memorialize their agreement in a marital settlement agreement. If folks are able to do that, it's going to save them time, it's going to save them a lot of money in terms of legal fees, and then that can be easily put into an order of divorce, and it's really the best case scenario for the parties involved. In terms of a mediator, the Maryland Department of Agriculture offers an agricultural conflict resolution service. That's a mediation program, and that can be used for valuing marital property when spouses have issues regarding agricultural credit or lending or USDA-related programs and loans. Okay, so sorry, all. Hope for the best, plan for the worst. That's my romantic advice to you on Valentine's Day regarding farming and divorce. Consider a prenuptial agreement. If you have young people in your family who look like they're heading towards a marriage, can talk to them about it, explain to them the importance of a prenuptial agreement. If you receive assets during marriage, consider keeping them separate and maintaining them as non-marital property now that you've heard this explanation of the importance of doing that. Consider divorce during succession planning. So think about what would happen to your family farm in a divorce. Think about, make that part of your succession and estate planning consideration. Instead of a typical gift, use a trust. And for more information on all of this, check out the ALEI publication, Protecting the Family Farm in Divorce. It's on the publication library tab of our website, umaglaw.org, and I've also given you the link here. So that is all I have for today. Thank you all for listening. Feel free to put any questions you have in the chat box. There's my name, my email, my phone number. I'm happy to try to help you. We can give folks answers to legal questions. We can't give folks individual legal advice. If you need individual legal advice, I'm happy to try to refer you to a qualified attorney. So does anyone have any questions?
All right, there's a chat pod down below if you have any questions for Sarah. I'm going to go ahead and stop recording.